Hi, everyone. Thanks so much for joining this afternoon. We're gonna get started in just a few moments, so hang tight, and we'll start shortly. Thank you. Good afternoon, everyone. We'll give it just one more minute so that folks can join. Thanks for being here. Okay, good afternoon, everyone. My name is Amy Salata. I'm the Outreach and Advocacy Manager at the Student Borrower Protection Center. Thank you so much for joining us here today for the 2025 PSLF negotiated rulemaking briefing that we're doing this afternoon. We appreciate you all being here. If you have questions throughout the presentations, please feel free to use the Q&A feature at the bottom of your screen. We look forward to answering as many questions as we can later on this afternoon. First, we'd really like to kick things off with Liz King from the Leadership Conference on Civil and Human Rights. So please welcome Liz, and thanks very much.
Awesome. Thank you so much, Amy, and thank you so much to SBPC for having me. And just like a huge, special thank you to Abby and Betsy and all of the work they did during the negotiated rulemaking that you will hear more about in this webinar. Just a good reminder of the power of solidarity and how important it is that we show up for one another. And that when you're in a space, when you're at a table and there isn't room for someone else, you think about, how do you carry their voice with you? And so just wanted to say a huge thank you to both of them for the work that they did in a very unpleasant and awful negotiated rulemaking. So we are talking here about yet another attack by the Trump administration on civil society and equal opportunity. And the manifestation of this latest attack that we're talking about and focused on today is a regulation governing public service loan forgiveness. Now, we know that they've been very transparent about their hostility to public service loan forgiveness, their hostility to public service, their hostility to loan forgiveness, and their belief about what the pursuit of higher education should mean, what it should cost for students, and how few students should have access to that opportunity. But what we're seeing here is not just an attack on access to higher education and not just an attack on economic opportunity that comes with having gone to college. We're seeing an attack on immigrant communities, on trans and LGBTQ communities more broadly, on those who pursue equal opportunity, those who seek to change government policy, and those who are mislabeled, incorrectly labeled as terrorists or as engaging in illegal discrimination. I think it's important to ground the conversation today with the memory and the context, the historical knowledge that in 1956, the state of Alabama banned the NAACP. So there is a very clear through line to the history of using the law and using law enforcement as a way of precluding people from engaging in activities that would advance equal opportunity, that would ensure our constitutional rights are real and available to all people. We have seen these extortive policies through the Trump administration, and it is a tool of extortion. They are trying to compel changes in disfavored activities and disfavored perspectives through extortion rather than even through the formal enforcement of our laws. Largely because what they seek to do, and you'll hear a lot about this from the great folks at SBPC about how wildly unlawful this proposal is, Because what they are trying to do is illegal, because it does not have a basis in law, they are using extra legal tools to try and create change. So we've seen folks hauled in front of congressional hearings because they help immigrants to know their rights and to understand what rights are available to them. We've seen threatening letters sent to all sorts of schools and school districts and employers and organizations, 501c3 organizations. And then, of course, what we've seen time and time and time again is the use of threats of lost funding as a way to compel, to advance their agenda around viewpoint discrimination. And so when we, the civil and human rights community, are looking at this moment with respect to what's happening with public service loan forgiveness, we are here to show up and defend public service loan forgiveness, to defend access to public service loan forgiveness and the promises made in the law that Congress passed. But we're also here to talk about where this fits into a larger context that is an attack on civil society. It is an attack on protest. It is an attack on free speech. And it is an attack on our opportunity as Americans to exercise our constitutional rights. And so you're going to hear a lot more about the language, the verbiage that was used during the negotiated rulemaking. That process is inherently incredibly wonky, right? You're going through, you're looking at lines of text. We're going to go and we're going to hear in this webinar what the actual text of the proposal said. Some of those words are heinous words used to describe people we know, love, care about in our own communities ourselves. But we're going to think about that. We're going to think about using these tools, and we're going to keep in mind the broader context here. So we're going to hear about the process. So there is going to be a draft rule, a notice of proposed rulemaking that's published. And then everyone who is on this call and everyone they've ever met is going to submit a comment into the Federal Register talking about how heinous these changes are, about not only how the Department of Education shouldn't do this, but that they can't. And then we're going to continue to engage throughout the process as we see what happens with the final rule and eventually litigation. So thank you so much for having me. Really excited to hear the rest of the conversation and continue working in partnership with all of you. I'll hand it back to Amy.
Thank you so much, Liz. We really appreciate you being here and getting us fired up and ready for the conversation. Next up, we'll have Winston Berkman-Breen from the Student Borrower Protection Center to give us a little overview of NEGREG and also the proposed rule. So take it away, Winston.
Thanks so much, Amy, and thanks everyone for joining. So as you just heard from Amy and from Liz, and thank you for sort of the level setting there. There's a lot going on. The goal of this webinar is to get everyone up to speed on the legal policy sort of democracy concerns here. So I'm going to spend a few minutes making sure we're all sort of on the same page about what has happened before I turn it over to Betsy and Abby, who were negotiators in the room last week, to share their experiences, and then we can go from there. So I'm going to share my screen. We'll come up just to show you and reiterate this agenda. And, you know, we've already had a level setting, so I'm going to jump straight into overview of NEGREG, a term we've sort of tossed around in the PSL proposal. So first of all, what is negotiated rulemaking? So negotiated rulemaking is a special process that the Department of Education has to go through when it wants to make new regulations related to federal financial aid or change existing regulations related to federal financial aid. Writ large, when any federal agency wants to do rulemaking, it has to follow the Administrative Procedures Act and do a public comment process. This special negotiated rulemaking takes place before that. So basically what they do is they, and they've already done these steps on the screen, is they have a public hearing after they announce certain topics they're going to have a negotiated rulemaking on to get general input from the public. That happened late spring. And then they convene for usually multiple weeks, during which they meet, you know, for the first 4 or 5 days of the month for a couple of months. So a couple, you know, 3 or 4 weeks in total, spread out over 3 or 4 months, with stakeholders from various representatives from various stakeholder communities to talk about the Department of Education's proposal for the new regulations or changes to regulations that they want to see. Those stakeholders and their representatives then vote on, they negotiate, and there are changes made to the language in theory, and then they vote on the language at the end of the negotiated rulemaking or NEGREG session. If there is consensus on that language, that does not mean that the language turns into the new regulation. What it means is that that language will be then presented to the public for comment, and the regular APA notice and comment rulemaking goes from there. If there's not consensus, the department will put forward for comment whatever language it would like. And again, the regular APA rulemaking goes from there. So having said that, who were the constituencies, the stakeholder group? So you'll see this out in front of you. For a question being posed to this group about public service loan forgiveness, it's more than unfortunate. It's deeply problematic that we did not have more constituencies here that represent public service workers and borrowers. Typically, that civil rights, consumer advocates, and legal aid group at the very top, which is one constituency for this neg reg, are disaggregated. Typically, there are 2 or 3 constituencies, and there is borrowers in repayment here, third from the bottom. But in general, very few of these stakeholders have a real stake, so to speak, in public service loan forgiveness or borrower outcomes. Sometimes these stakeholders are important because the regulations being discussed are relevant to them. I would say that's not the case here. And again, we're going to hear from the 2 representatives on behalf of the civil rights, consumer advocates, and legal aid seat, Betsy and Abby, in a couple of minutes. Okay, so again, level setting, what is public service loan forgiveness? I don't want to assume that we all know what it is, and I'm going to sort of give a high level reminder so that you can understand the proposed changes. So public service loan forgiveness was created by Congress in 2007, signed into law by George W. Bush. Basically what it says is, if you are a federal student loan borrower who works in public service for 10 years and you make payments during those 10 years, you can get your debt canceled at the end of that period. So it basically has 4 elements, right? It's not just any federal student loan borrower. You have to have the right kind of loan. You've got to make payments on the right type of payment plan. You've got to have the right type of employment, and you've got to make 10 years worth or 120 payments. Those are the basic elements of PSLF. Okay, so then that's like, the background. Trump administration, in March, the administration issues an executive order called Restoring Public Service Loan Forgiveness. Basically, what it would do is it says it wants to disqualify certain employers from their workers being eligible for PSLF if they engage in activity with a, quote, substantial illegal purpose. The executive order goes on about needing to sort of, good fiscal stewards and not wanting benefits to run to organizations that do unlawful activity. On its face, at first pass, for someone who's not sort of looking too hard, that sort of makes sense. But then I think, as you'll see during the rest of this presentation, it really falls apart pretty quickly and is very alarming in what it's suggesting. So there are 5 buckets here of activity that the executive order said would have a substantial illegal purpose. And I'm just going to spend a moment on each one and sort of decode it for the group. So the first is aiding and abetting violations of federal immigration law. That sounds, first of all, if someone's engaged in illegal activity, that's a court decision, but we'll talk more about that. But aiding and abetting violations of federal immigration law. I'm about to sort of give examples for each of these, and I just want to be clear that these are like examples of how this might play out, not exhaustive. This could mean so many things, but at the very least, we think it means, someone who defends immigrants against illegal deportation, right? Something that the Trump administration does not like to do. The next one, supporting terrorism, including by facilitating funding to operations of groups designated as foreign terrorist organizations, engaging in violence for the purpose of obstructing or influencing federal government policy, but supporting terrorism. These days, the Trump administration might see supporting terrorism as advocating for the end of the war in Gaza, or many other things, right? This is a very vague term, supporting terrorism, that this administration has and could very easily continue to weaponize. The third bucket, child abuse, including the chemical and surgical castration or mutilation of, or the trafficking of children to so-called transgender sanctuary states, right? This is just very clearly providing gender-affirming care to minors, right? They sort of say it in there. Again, could mean other things as well. Engaging in a pattern of aiding and abetting illegal discrimination. There are so many ways that this administration or another similar administration could weaponize this in a really harmful way, but at the very least, just the attack on DEI, right? This very easily could be the basis for engaging in substantial illegal purpose. And finally, engaging in a pattern of violating state tort laws, including trespassing, disorderly conduct, public nuisance, vandalism, etc. What are the name of this? Right to peaceful protest, right? Dissent, public dissent. So again, these are just one example per category of how these so-called substantial legal purpose activities could be weaponized against civil society, right? And really, they all aim to change that element of PSLF about employment, which is a pillar of the program, right? They basically want to say your employer does not qualify if you engage in if it or you engage in one of these, frankly, protected activities, regardless of whether they're actually lawful or unlawful. They're going to call them substantial illegal purpose activities. Well, the problem with that is the federal law that was passed in 2007 and Bush signed into law for PSLF defines who an eligible employer is. Again, this regulation would redefine who an eligible employer is and exclude some employers. But the federal law basically says that you qualify if your employer is a government or a 501c3 nonprofit. It is just in the law categorically. There is no discretion for the Secretary of Education to remove some of those employers and make them ineligible or disqualify them. But that's exactly what this proposal would do, is it would say you might be a government, but if you're a government that's a sanctuary city, we're going to say you're engaged in substantial legal purpose activity, and that will make you disqualified from PSLF, and your entire workforce will be disqualified from PSLF. Okay, so that was the executive order, right? The rule that was proposed and subject to NEGREG basically just codifies that. It takes those exact 5 categories that we just walked through. It turns them into reg language by adding some definitions and folding it into the existing PSLF regulations. It takes the qualifying employer definition and basically said this qualifying employer does not include anyone engaged in a substantial illegal purpose activity. In terms of how the Secretary proposes and the Department of Education proposes this would work, it would basically be up to the Secretary to determine which employers will be disqualified, which are engaged in an activity with a substantial illegal purpose. Now, they say that, they offered a sort of a system, notice and an opportunity of the employer to be heard, and the Secretary will use a preponderance of the evidence standard, which is just more likely than not. That's not a particularly high hurdle. And that there are 3 types of evidence that would just be conclusive, right? It's not even a secretary weighing the different evidence. And those 3 types of evidence that would be conclusive, which means you're definitely disqualified, is if there's a court order finding that you engage in one of these, if you have a guilty plea, or if you admit in a settlement that you engage in one of these activities. Now, the secretary, outside of these 3 examples, these 3 types of evidence, can still just decide that an employer is disqualified based on activity that has a substantial illegal purpose. As it was initially proposed, there was no appeal or reinstatement opportunity. Basically, an employer would have to go to court, which seems unlikely because it only hurts their workers. It doesn't actually hurt them. It doesn't penalize the employer who allegedly engaged in illegal activity, even though we can all understand it's not actually illegal activity. It hurts the workers. And this would have taken effect as proposed starting next summer. So the negotiators, I'm going to not talk through a lot of this because Betsy is going to speak to this in a couple of minutes, but the negotiators raised a lot of concerns, both legal and sort of constitutional and policy, as well as practical and in nature. And it's like, how is this going to work? Or I don't think, you thought this idea through so well, Department of Education. And again, we can come back to this slide, but I'm going to leave it to Betsy and Abby to speak to this a bit more directly. And the department sort of went through some motions to incorporate some of the feedback. I mentioned initially there was no opportunity for an employer to be reinstated if they had been excluded from the program, which meant their current workforce could never get PSLF, or they'd have to change jobs to get PSLF. They proposed a 5-year period after which they could be reinstated. They tweaked some definitions, but none of this really took the proposed regulation and address some of the core problems about policing speech and policing legal activity, and whether the Secretary of Education is even an appropriate person to make some of these determinations, right? Ultimately, I mentioned this consensus process. If they all vote yes for it, all the negotiators, then The final language as is will be proposed to the public for a comment period, as all federal regulations are, and then a final rule will be issued that's supposed to be responsive to those public comments. There's about a dozen or so negotiators. You saw the categories earlier. Every seat had an alternate as well. Of all of them, only one person, Betsy, who you'll hear from in a moment, voted against this process. Otherwise, it was unanimous in support, which is really shocking, frankly, especially because some of the negotiators raised concerns. And I think it speaks to the sort of boiler room pressure that was being put on folks to have a consensus vote. So again, Betsy can speak to that more in a few moments, but she was the only no vote in this whole process. Okay, so actually with that, I'm going to take my slides down and hand it over to Betsy. My hope is that that provided a background on what we're talking about here. Again, PSLF as a program and your eligibility running through your employer, and that this proposal would allow the secretary to disqualify employers, thereby disqualifying their workers from PSLF if they engage in conduct that the secretary and the administration just don't like, right? The extremely broad and lots of discretion, including with respect to some protected constitutional rights. Not to mention that there's no language in the statute that creates PSLF that gives the Department of Education this authority. Congress would have to do some of these changes. So I'm going to pull down my slides and I'm going to let Betsy talk more about what it was like in the room, her experience, some of her concerns that she and others raised with respect to the proposal, and then we can go from there. All right, Betsy, over to you.
Thanks, Winston. So this was my 5th or 6th time being at the table as a negotiator. I was part of the first bar of defense. I was part of whichever one changed the rules for loan rehabilitation. I did one for foreign schools. I don't remember the other ones. And I've been in the room for every student loan related NAGREG since I believe 1999. So I'm old. And I've seen the good, the bad, and the ugly with NAGREG. I personally love negotiated rulemaking when it works the way it's supposed to. This is going to sound super corny. But the idea of having all affected parties in the room to make sure that the regulations that are written are the best reg we can come up with for all the affected parties is democracy at its best. When you go into negotiated rulemaking, you have to consider, again, all the affected parties in the room. And it's incredibly rare to get everything that you want. So going in to a NAGREG, saying to yourself, I'm going to vote no unless I get everything I want, it's not necessarily negotiating in good faith. Oftentimes you do have to compromise, and again, come up with the best regulation that can be obtained for all parties involved. And I have seen that happen more often than not, I have to say. Again, we don't always like all the things that come out, but someone a lot smarter than me once said that if you can get a regulation that helps 80% of the people, you've done a good job, because there's always going to be outliers. I say all that as a background to say that this was not that. This particular NAGREG, I don't think that everybody at the table, particularly the department, were necessarily negotiating in good faith. I think they had their marching orders with the executive order, and they didn't feel that they could stray very far from that executive order. But I also think it was very important to them to signal to the White House that they could get consensus. And I want you to sort of park that in the back of your mind when I explain a little bit of how things went and where the pressure came. So Winston did a great job explaining the initial proposal. So from there, we started so-called negotiating. And because of that so-called negotiating, the Department of Ed made what they called concessions. One of those concessions was adding a process where an employer who was accused of these so-called illegal activities could defend themselves from that accusation before they were actually deemed as ineligible for PSLF purposes. They also, as Winston pointed out, added a mechanism for someone who had been kicked out from PSLF eligibility to be added back into the fold, so to speak. To me, those were two of the big things that they considered to be concessions. Along the way, they also changed what they would consider to be their legal definition or the evidence standard that they would hold employers to. I think it started as clear and convincing, and then it went to the preponderance of the evidence. And then at the very last minute, when they were trying to convince me, not even to say yes, but to abstain from the vote, they offered to change it to severe and pervasive, for which there is apparently an understood legal standard for that. And when they were trying to get, and there were other issues for, another one that came up a lot was the definition of a minor. And this was to me a weird hill for them to die on, but they insisted on making the definition of a minor the age of 19 rather than just using the word minor or making it state specific. Apparently there's one state that defines a minor as someone under 21, and there's another state that defines it as under the age of 19. They seemed unwilling to move on that, which again, to me was kind of a weird hill for them to die on. When we got to, and I guess I'm sort of getting ahead of myself. Let me park day 3 for a second. So my strategy going in was to really sort of push, which to me was the bottom line of the issue. And as Winston pointing out, they don't have the authority to do this. The Department of Education has the authority to promulgate regulations, but those regulations cannot be contrary to federal law. Fun fact, neither can an executive order. So I wanted to wait to really push that piece until day 2. My strategy being I wanted to listen to what the Department of Ed had to say in their introduction of the proposal, and I was pretty sure that somebody else at the table was going to push back on that a little bit, and I wanted to hear what they had to say before I sort of launched my big sort of soapbox moment on that, which I did on day 2. And I've got to tell you, I was very surprised at the department's lawyers and the other department peoples at the table, their response. I mean, I would have expected that they would have expected that was going to be the big pushback, that you don't have the authority to do this. And I expected them to have a stronger argument. And all I heard over and over again was when I said, you don't have the authority to take away PSLF status from government and 501c employers, their response over and over again was, we have the authority to promulgate regulations. And my response said, 100%, but those regulations cannot be contrary to federal law. So again, I was a little surprised by that. And I don't know if it's because they were just unprepared, and that was to me was, if that's the case, that was surprising that they were unprepared for that, or if they just don't have an argument. So I'll be interested to see when this inevitably goes to court, if they have a sort of a stronger argument there. The next sort of big point that I personally was arguing was the ability of the Department of Education themselves to decide, you did this illegal thing. And my argument there was, first of all, this isn't your wheelhouse. It's not the Department of Education's role to decide if an employer violated discrimination or these other laws. That's the court's role. And, discrimination and whether someone committed terrorism or these other things it's not your expertise. And so I was asking them over and over again, and this became the big sort of point in contention at the end, to remove the sort of arbitrary department authority to make this decision if a court hadn't, or there wasn't a plea of guilty or a settlement where the employer admitted to have engaged in these substantial illegal activities. The department's response, the other thing I pointed out is that there's already a process to remove 501c3 status that the IRS has. And it's a process where the employer, if they're if their 501c3 status is being threatened, has the ability to defend themselves, and there's a way for them to get back into the fold. And at one point I said, I feel like the executive order is requiring you to ensure an outcome, and there's already a path for this outcome, so why are we here? And they sort of hemmed and hawed about that a few times. And then at one point, and I don't know if this was a slip or not, they said because these other processes aren't fast enough. And I think that comment was really telling. So in the end, on day 3, I started getting a lot of pressure, not to say yes. I think they knew I was never going to say yes to this, but to abstain. And by abstaining, they were hoping, which they eventually did, to get their consensus. And I think the reason they thought that they might be able to convince me to abstain was because one of the things, if the group comes to consensus, it means that the negotiators are not allowed, no matter how they feel, to comment negatively on the NPRM. And a lot of times that's really important to the negotiators, especially if you remember what I said in the beginning, that the regs almost never end up perfect. So if you had to compromise on something that was really important to you to get something else that was even more important to you, you might still want to comment negatively on the public record on the NPRM. So when they were pushing me to abstain, one of the things they kept saying, if you abstain, then you'll still be able to comment negatively, which would have been true. But I also can comment negatively if I say no and we don't come to consensus. So that to me wasn't a temptation. It wasn't by any means a strong argument for me to abstain. And then the pressure was, if we don't, and they said this at the table and they said this in the private caucuses, if you don't come to consensus, and therefore if you don't agree to abstain and allow the rest of the group to come to consensus, we've made all these concessions and we're going to pull those concessions. So in the end, in the final sort of offer where they agreed to change the level of evidence to severe and pervasive, I did think very hard about that, because severe and pervasive is a fairly high legal standard, and there is case law behind it. And I wondered if that was something that I was willing on behalf of borrowers to lose, and these other so-called concessions. And just to explain where my thought process was, um, you know, Abby was a huge support, and other members of this group were a huge support. And it can be hard, but we didn't have time to go back and really talk to the whole constituency and think it through. I'm one that likes to sleep on things, and I was just afraid I was missing something, and I didn't want to harm the constituency more by at least not agreeing to abstain. But in the end, what dawned on me, and I wonder, Abby, if Abby will say that she literally saw the light bulb pop up over my head, is that these so-called concessions that they were threatening to pull weren't concessions at all. They were portraying them as favors, and they certainly weren't favors. Now, as I expressed multiple times at NAGREG itself, but for those of you that didn't hear it, I'm not an attorney, and I don't try to be one. But one thing I do know is that any time an entity is accused of illegal activity, there's required to be a process for them to defend themselves. So take away the tenuous at best legality of the proposal in and of itself, of whether the department has the authority to take PSLF eligibility away from these employers for any reason, it becomes even more legally shaky if there isn't a process for these entities to defend themselves when the department makes their decision that they've committed these illegal activities. So personally, I don't think they're going to take away these so-called concessions, because it will make the proposal on even shakier legal ground. The other thing that was, I don't think I really needed this, but it was a real push, over the edge or confirmation of what this proposal was all about is I found that there was a press release that was issued by the department on June 30th, where they, quote unquote, accused Harvard of violently violating discrimination law. And that to me was just signaling that they've sort of already made their decisions over what, illegal activity means. And that I think that there very well could be a target list for these things here. So even though I did struggle for about 15 minutes, and again, Abby was a huge help helping me to, think this through out loud and making some really great points to me. Once that light bulb went out, it was like, it was such an easy decision to abstain. And so that's sort of the story behind all of it. I've never been put in that position before. I do think the fact that we only had the one meeting was challenging because it made it difficult to review new proposals that were coming out. And one of the values of having multiple meetings over time is it gives you time to think and perhaps come up with some more elegant language that appeases most of the constituency at the table. That was never going to happen in this one anyway, but that's one of the things we lose by having such a shortened timeline. I don't know am I leaving anything out?
Yeah.
But
And you can certainly we're going to have a chance to sort of circle back, Betsy, if you have more thoughts. If you do have additional things you want to say, go for it. Otherwise, we can see if Abby wants to supplement anything.
yeah, I'm done.
Yeah. Well, thank you both for your service last week, Betsy, and for sharing those thoughts, which I really hope, I was there for the first day of it and watched online afterwards, really rekindled a lot of my rage, frankly, about the process. And I wasn't even in the hot seat, so to speak. But I want to hand things over to Abby, who was the alternate consumer legal services civil rights seat along with Betsy. And Abby, I think Betsy did a good job about, again, talking about her experience as a negotiator and talking about her perception, I think her accurate perception about what the Department of Education's incentives were here and what their goals were and some of the sort of minor concessions and overall tactics they use. If you want to add anything to your sort of personal experience, that would be great for the group. And then, Betsy noted that she's not a lawyer. You are a lawyer. If you have any additional thoughts on the department's interactions and responses with respect to their legal ability, their legal authority to do this, which again, Betsy touched on, but I think can't be overstated in this conversation right now.
Yeah, sure. And I hope everyone will pardon me and or call me out because I'm just joining from another meeting. So I unfortunately didn't get to hear all of what Betsy said. So I apologize in advance for any repetition. Betsy and I we're very much on the same page, I think, in this rulemaking. But in terms of personal reflections, I think that it was clear that this rulemaking was not going to result in rules that were going to protect borrowers or make sense for the legitimacy and ability to have faith and trust in the public service loan forgiveness program. That unfortunately, like the executive order behind it, was just really, really troubling on its face and departed dramatically from what Congress designed the public service loan forgiveness program to do, and the contours that Congress put on the program. And so we really pushed back in terms of the legal authority and in trying to get the Department of Education to grapple with and attempt to reconcile what it was proposing with the true limits on their authority. And unfortunately, they had their lines in the sand, and we had our lines in the sand. So we weren't going to come to consensus as a result of those lines. I think, Betsy and I both certainly raised a lot of concerns and issues with the Department of Education's legal authority to do this. And in particular, in just overall, the Department of Education's legal authority to limit which government employers and which 501c3 employers in particular are qualified to participate in the Public Service Loan Forgiveness Program. We emphasized that while certainly the Department of Education has authority to implement the Public Service Loan Forgiveness Program and to interpret any ambiguities in the statute in order to create a clear, whole, functional program, that there is no ambiguity for the department to interpret in terms of the definition of public service work, that Congress clearly and explicitly said public service work means any full-time job in government, excepting only time served as a member of Congress, and any full-time work at a 501c3 organization. So there's no ambiguity there. Congress didn't say, except if they engage in certain disfavored activities, except if the department determines that they have engaged in illegal conduct. There's none of that there. It's a very clear and straightforward definition. And I think Congress defined it that way for a reason. It was a bipartisan program that was really intended to support work in government and nonprofits. And I don't think it would have been a bipartisan program and received that support if it had been framed as a benefits program that whoever the acting administration could sort of pick winners and losers amongst at their discretion. So we raised those legal concerns. I did not find the Department of Education's responses at all compelling. They kept coming back to the Department of Education has broad authority to regulate student loans. The Department of Education has broad authority to regulate the Public Service Loan Forgiveness Program without acknowledging that authority has its limits. And those limits are really clear, where Congress has clearly defined the program and has defined for itself what it means to be a qualifying public service employer. And that therefore, the Department of Education doesn't have any authority to create new rules that conflict with that definition. I can pause there and see if there are any other questions.
Yeah, I think that is, I want to make sure we leave time for like sort of Q&A style questions. And if you can jump in at that point, maybe let's go to the next step of this and then we can all circle back on in a few minutes. But I think, so far Liz kicking it off and then Betsy and you have really hit home the idea that not only is this like alarmingly bad policy, and it's not really alarming just in the context of people with student debt and who work in public service, it's like what it represents for this administration's view of its own authority and power across civil society is like alarming, but it's also illegal, right? And it's like, I don't quite know, like those two things are sort of tied for first here, right? They're just so blatantly and like in a very gaslighty way saying it's not illegal, don't worry, we have authority to do this horrible thing we're doing, but isn't this horrible thing actually good because we don't want money to go to illegal activities, right? And I think that's sort of like something we're hearing in concert across the folks who are in the room and who've been watching. So just for a few minutes, I want to wrap up sort of like the mechanics of how this rule goes and negotiated rulemaking in general. And then we'll have plenty of time for Q&A and we can get Betsy and Liz and Abby and everyone else who's been on to sort of weigh in and help answer folks' questions. Okay, so we've heard from Betsy, we've heard from Abby. So I just want to very quickly spend a minute talking about, all right, what's next? Like, how does this work before I pass it over to my colleague Aisa from the Student Bar Protection Center? So next steps, as I mentioned earlier, neg-reg is just a precursor, right, to typical notice of proposed rulemaking, APA rulemaking. So there was no consensus. Thank you, Betsy. So the Department of Education will be able to propose sort of whatever language it wants to the public for comment. It will likely look like what was proposed and discussed last week, just because they so clearly were fitting a rubric from the executive order that I don't think they're going to wiggle too much. They might incorporate some of the suggestions and sort of what Betsy called the concessions to make it seem more reasonable for the public comment period, but they're not bound to, and we'll see what they ultimately do. They will probably, in this part, we can't say for sure, release the proposal later this month with a 30-day comment period. And the reason we think that is because the way what's called master calendar, or the general scheduling around negotiated rulemaking, works for these kinds of programs is that they have to finalize a rule. So get public comment, read them all, respond to it, and publish final rule by November 1st of a given year for that new rule to take effect by July 1st of the following year. So this is specific to the Title IV federal financial aid student loan regulations. So if they want this new PSLF program, the ability to exclude certain employers, to be in effect by next July, they have to get it done by this November, which is why we think they're going to rush through a quick 30-day comment period as soon as possible. After that, November 1st, we'll have a final rule, and probably, whether it's folks on this call or otherwise, there's just going to be lawsuits, right? We're going to have a couple of months before the rule takes effect, but this is on its face illegal, in violation of statute, and unconstitutional, and there will be lawsuits filed to challenge that. But the next step is that comment period. So I want to turn things over to my colleague Aisa, who's going to talk about sort of the organizing and advocacy opportunities on the horizon. Over to you.
Great, thank you so much, Winston. And I know we want to get to questions and answers, so I will be very quick. So as Winston had mentioned, we will have a very short window of time to get this out into the public and to encourage our respective organizations as well as memberships to really weigh in and put their comments on the record as to why this rule is blatantly illegal, dangerous, and as Liz had mentioned at the top, just part of really a series of attacks from this administration on civil society and on organizations that are doing the work to support our most marginalized communities. And so one of the reasons why we wanted to have this briefing is to get this on folks' radar, because we know that NEGREG happened during a crazy week when many of us were having to split our attention across multiple areas. And get folks ready to act once we do see this proposed rule and that 30-day window eventually opens. So, but I think first and foremost, we really need to, our top priority right now is to build the narrative as to why this rule is so dangerous and is and really couch it into this larger attack that we've seen from this administration on nonprofit organizations and on civil society institutions and organizations across the board, and really telling the story about how this is part of that larger wave of attacks, and really attacking various First Amendment rights and freedoms of expression, et cetera. And so we are, we here at SBPC and many of our partners want to make ourselves available as resources if your organization is interested in any type of op-eds or written pieces about why this rule is so dangerous, or why this proposed rule could be so dangerous, and how it could affect your organization or the space in which you are working in or the communities that you are serving. So please feel free to reach out if that is something of interest to your organization. And then to the point that Winston raised earlier, the comment period is going to be a critical moment in time, right? So we here at SBPC are planning on drafting a coalition comment with the hope of having as many organizations as we can get to sign on. So, and I think at a very high level, the letter, we are going to try to keep it very short and sweet and really keep it to those 2 points, in that this is blatantly illegal and a part of a broader attack on our rights and liberties, and will have a chilling effect across civil society writ large. I think we are going to want to inundate Ed with as many comments as possible, but know that many of our organizations on the call here today are coming from multiple spaces who might not necessarily live day in and day out in kind of PSLF land or even on education issues specifically. And so we want this coalition comment to be an opportunity for organizations that might not have the capacity to do their own letter. Please know that this is an opportunity that will be made available to folks, and we welcome anybody and everybody to sign on. And so please look out for an email from my colleague Amy once that coalition letter goes live. But our plan is once we see a proposed rule announced, that we will, under very short order, get a coalition letter circulating so that folks have as much time to work things up their respective chains to sign on. And then we also, you know, as we're thinking of how to best inundate the department with letters, if you're signing on to the coalition letter, great. But that does not prevent you from also submitting your own organizational letter. And so we are hoping to encourage comments from employers that could potentially find themselves in the crosshairs of this terrible rule, and encourage them to submit comments as well. And so we at SBPC are happy to be a resource to provide kind of some ideal framing and messaging, and can even offer a template if that is of interest. And so we are planning on spending the next couple of weeks before we see this rule, doing some individual outreach and meetings with organizations that might be interested in submitting an individual organizational letter or comment. And so if you are interested in having a conversation with SBPC, feel free to reach out to myself or my fabulous colleague Amy, and we can make sure to find time to provide any kind of like guidance or suggested messaging, if that is of help. And then we are also really hoping to garner a lot of borrower comments and so comments from borrowers. So we are thinking, or we are putting together a template that will help organizations kind of customize and blast out to their memberships to encourage borrowers to weigh in on how this rule is so dangerous. And so please keep an eye out for that. And if that is of interest and you want to see something, an earlier version, or want to talk about these things before this rule comes out, please do reach out. And then we will also be doing some outreach to members of Congress to encourage them to weigh in through this comment period, to make it very clear that this rule falls just blatantly outside of the, you know, the legality and out of the, you know, very clear black and white of the PSLF statute. And then last but certainly not least, as Winston had mentioned, you know, there are going to be lawsuits that are going to be filed. And so if folks are interested in potentially being plaintiffs, we are happy to have conversations with folks. I know many of our respective organizations have been in touch about moving forward with litigation. But these were all kind of aspects of this process that we wanted to make sure were on folks' radar sooner rather than later, because I think this is going to be a very short window of opportunity that we have to push back against this rule, and make it very clear, you know, why it is such consequence to not only organizations working in this space, but to our broader democracy and country at large. So with that, I am going to stop talking and I will turn it back to my colleague Amy.
Amazing. Thank you all so much. That was such a wealth of information. We are getting some questions in. If you have questions, please throw them in the Q&A. Just to address right at the top, we will be able to share this PowerPoint with folks, so I can send that out in a follow-up email. In addition, just for time's sake, I'm gonna start asking some of the most pressing questions. Some folks are wondering, what is the best way of folks on this call to engage? Is raising the salience through our networks productive, and what sorts of messaging seem to be most constructive? I'm not sure if anyone on the call wants to maybe recap ways to engage very quickly. You know, the NPRM comment period will be coming up shortly. We'll have a coalition letter to sign on, as well as if folks want to engage in their own comment letters. Anything else to add on that front? You know, as well as the like litigation that Aisa mentioned too, but anything else to add on that front, on this question from any of the panelists here today? Feel free to, jump in. Betsy.
Yeah, I just want to make sure that people are, if you draft your own comment, which I do, I encourage, they tend to ignore sort of duplicates um, to an extent historically. But be thoughtful in your comment. And what I mean by that is don't give them any don't give them anything to hold on to. That what I'm thinking of specifically is when people under this proposal bring up, well, this will hurt employers. The department's response is good. That will encourage them. We're using this as a way to discourage employers from engaging in such activities. So again, when you're writing your comment, be thoughtful and make sure that you're not giving them any gifts to or additional arguments to make in their final rule.
Thank you, Bessie. Abby, did you want to add anything?
I think first, it's always great to focus on like the impact on like people who benefit from all the public service work that these people do and how they'll be harmed. I think that's like a great way to frame it. Like students who will be without teachers, rural communities that will be without hospitals. Those sorts of framings, I think, are really effective. I was going to add that certainly if you're thinking of doing submitting public comments, that like that's your sort of inside game, but that you might also thinking about if you're doing the public comment, would you also do a press release to accompany your public comment? Might you also consider writing a letter to the editor or an op-ed about this issue and how it would impact important constituencies or like what your concerns about it are. So think about, not just sending it, submitting it on regulations.gov, but getting this talked about, out in the public space as part of this larger narrative and public education about what's going on.
Thanks, Abby. Liz, did you have something to add?
Yeah, just to reinforce a couple of things that Betsy said. I mean, I think it is really important in all of our public messaging about this and in the context of comments that we submit that we are clear how outside the realm of reasonableness this process and this rule is. Like they are trying to pretend like this is a normal thing that happens. Of course, there are partisan disputes about things. This is not that. This is not Democrats versus Republicans. This is a wildly different thing where they are trying to essentially turn the Department of Education into the IRS and then use that to shut down speech they disagree with. And I think it's going to be really important to be clear how far outside the realm of normal this really is. And I think so much of the NEGREG, they were really focused on like, let's, have a conversation and let's, think about how to change this word or that word, when the underlying thing they're doing so clearly violates multiple laws, including the First Amendment. And that using the phrase viewpoint discrimination, I think is going to be really important here when we're talking about this, because it really is, I mean, again, Betsy's point, like, it's not that they didn't think this would hurt employers. They are intending to hurt employers. And the way they're intending to do that is not by enforcing this provision. It's by threatening to enforce this provision. They are trying to persuade people to stop doing things that are perfectly legal, right? And so I think that's the other thing to really keep in mind. And again, the volume of the comments, they have an obligation under the APA to respond to comments. So the more comments they receive, the longer it will take them to respond to those comments. If the process takes longer than that the October 31st deadline that Winston talked about, then it will not take effect in 2026. And so there is a real value here to getting as many comments as possible. I think signing on to comments is great. We'll be hosting a civil rights community comment as well, that everybody's welcome to join, but sending individual comments, making all of the arguments, talking about the importance of the public service loan forgiveness program and the importance of public service. All of that is great. And also to Abby's point, being as public and engaging as we can about what's going on here.
Thank you so much, Liz. I want to acknowledge that it is 4 p.m. and we can hang on for about 5 more minutes to answer some questions, some additional questions in the Q&A, but then we'll try to end as quickly at 4:05 as possible. So I just want to ask some more specific questions on who would be disqualified. So someone's asking about, could physicians and residents be disqualified from PSLF eligibility simply for being employed at a large hospital or academic medical center that provides gender affirming care, immigration related services, or other community-based supports, even when those services are legal under the state law and the individual physician is not personally involved? Betsy, take it away. I see you.
One of the things that they did make clear is that it would have to be a violation of law. Now, it could be, you know, if the federal law is at a disconnect with the state law, I think they might certainly try to go that way. But it does, they did say it has to be in violation of the law.
Yeah. So I think, oh, Abby, please go for it.
I was just going to add that the first draft of their proposal did not make clear, there was some tricky commas, did not make clear that they wouldn't be able to apply this also in states where it is legal. Basically would have potentially permitted them to punish employers in states where gender affirming care for minors is legal. And they initially defended that and said they thought they did have authority to do so. Over the course of a few days, they sort of walked back and they revised the language such that it would only apply where it is in violation of federal or state law. We don't know what's going to be in the proposed rule that comes out though. And so I think, it's not a time for everyone to immediately panic and to conclude that it will be applied that way across the country, but there's uncertainty. But what is clear is they don't care if the individual physician is personally involved, that it would be either an employer-wide policy or some divisions of the employer, but that they could potentially apply it to the whole employer, and they're not trying to pick and choose which individual employees are involved in the so-called illegal conduct.
Yeah, and I just there's 2 points I wanted to make. One is to sort of, that, only in violation of law is sort of specific to that example of gender affirming care, but other ones are aiding and abetting illegal immigration violations or what have you. And so not all the categories require violation of a specific law, the way it's been drafted. And then the second point Abby sort of touched on as well, just to really hammer home this idea that public service loan forgiveness currently runs through the employer identification number, like the tax EIN number, and most sprawling employers share, like the entire city of New York has a single EIN. The entire, UC San Francisco, if not UC system writ large in California, has an entire EIN. That's the campus, that's the research hospital, that's the everything, right? And so there's a world in which NYU, the undergrad college campus, gets deemed to be in violation because the secretary doesn't like how they've handled protests, and they accuse them, as Betsy mentioned of Harvard, accuse them of being anti-Semitic and engaged in unlawful discrimination. That could mean that a resident in NYU Langone is now disqualified from PSLF because they share an umbrella employer. And they did talk a little bit about ways to parse out that, like the back end mechanics to parse that out. But as of right now, that was just talk last week in a windowless room, right? The way that this gets implemented is unknown at this moment.
If I could just interject, because I don't want people to panic. That we actually talked a lot about that. Of all the things I'm afraid of here, I actually think the department is very open to parsing those out. I think if they don't, it's going to be because it's going to be an operational nightmare. I'm way more afraid of the operational nightmare than I'm afraid that the department's will be like, oh, the Boston Treasury Department did a bad thing, so therefore all the firefighters in Boston are also not going to be eligible for PSLF. I truly, call me Pollyanna, but but this is also from talking to Department of Ed staff behind the scenes. That is not going to be the intent. So
yeah,
I don't want
but
people to panic over this part. We have enough to panic about.
But I do think it is a good example of the indifference they have to the individual as a system, not individual workers. I don't need to get inside the brain of staff there, but there's clearly going to be, whether it's operational or intentional, collateral damage here, and they're pushing this agenda. They even said at various points, oh, well, we're limiting the harm to borrowers. This entire exercise is only harm to borrowers. It does not hurt the employer in the way that it hurts borrowers. The employers don't lose tax status, they don't lose workers, they don't lose funding through this. It only hurts workers with student debt. So I didn't mean to imply, and I cannot position to speak to their intent with respect to, who they want to hurt, but it very clearly only hurts workers. And so whether it's an operational hurdle or a policy hurdle, I just want to double underscore, like, that's at least my concern here. Whatever road we get there, we're ending in Hurtsville for borrowers, right?
And I would say it does hurt employers, right? Because part of what happens is nonprofit employers can't afford to pay as much as private sector. And
For
so
sure.
their employees benefit from PSLF, which enables them to have employees, right? The other dynamic here is that in order for this, and again, this is why I don't think it would be implemented, the Department of Ed would have to have decided that an employer had a substantial illegal purpose, and the IRS has decided that an employer does not have a substantial illegal purpose, right? What they actually want to do is take away 501c3. I mean, you said as much, Betsy, in the thing, they admitted that what they're trying to do is backdoor end run the IRS process, right? So what's going to happen here? Like, the idea that Ed would have a separate determination of what is essentially a 501c3's eligibility is cuckoo bananas, right? Like, there just is no world in which any of that makes sense. And the other thing here is, again, like, they withhold funds from Columbia. They call themselves doing that because Columbia violated Title VI of the Civil Rights Act, but that's not actually the authority under which they're withholding funds from Columbia. They're just calling themselves doing it for that reason, right? So they're going to use this to leverage. They're going to tell cities, you can't be a sanctuary city, because if you're a sanctuary city, you're going to lose PSLF for your public employees, which serves as a supplement to their income, right? So it is about, I mean, I think that's why they're less concerned about the implementability, because it is meant to be an extortive tool. It is meant to create an opportunity for a threat. And some employers, especially nonprofit employers, are not going to be in a position to withstand that threat. They will not be able to hire if they can't provide their employees access to PSLF. So, I mean, I think that's the big picture here as well to keep in mind, is that I think is their real end game here, is they do want to hurt employers. They want to hurt employers who are engaged in behaviors and in activities they don't think should happen. And that, I mean,
Yeah.
they're pretending to be doing criminal law and tax law and not education policy. None of this provides any benefit to any borrower now or in the future. There is no benefit to borrowers in this proposal.
Yeah, and I think Liz just said it right. I want to just correct my earlier comment. I think I was just being sort of flippant. It's not that there's no harm to employers. She very much should have there is. I just think it's very clear the harm to borrowers, and I'm not just saying this to, like, save face. I say this in part because this will actually be really important in how we litigate this, right? So I just want to make sure everyone walks away from this appreciating that it's, like, harmful to both in different ways, but both types of people, employers and employee workers, PSLF folks, are harmed in such a way that they should be able to go to court and challenge this. And so that harm is not just, on an interpersonal front, it's a legal concept as well.
And I just want to point out to Liz's comment that, you know what rhymes with cuckoo bananas? Chaos pajamas.
That's a
That
deep
is-
cut for those of you who don't follow the Bets and the Oat show, frequently.
I think that's the perfect note to end on. Thank you so much for joining today. Thank you to Betsy, Abby, Liz, Aisa, Winston for joining and sharing information with us. If we didn't get to your question, please feel free to email us. We're sorry we ran out of time, but it was great to have everyone online, and hope everyone has a great afternoon. Thank you so much.
Thank you, Amy.